gentlemen. This is the regularly scheduled meeting of the Municipality of Anchorage Board of Adjustment. Today is January 26, 2024, and it is apparently 10:12 a.m. We're a little delayed because we moved to another room. Would the clerk please call the order, or call the roll, I'm sorry.
Chair Guchow.
Here.
Member Probst.
Here.
Member Rose.
Present.
You have a quorum.
Thank you, Madam Clerk. I also should mention that there is next to me here the board counsel here for this particular case. That's Courtney Kitchen, as is the clerk, Jasmine Akers, and there is somebody else. I'm sorry, I don't know your name.
Brandy Easley, legal assistant, Assembly
Oh,
Counsel.
to Dean Gates. Okay, all right. So those are the people present. There are also people in the audience. I should remind the audience that you are here to listen, basically. At the end of the meeting, you have an opportunity to talk as long as you do not talk about the pending case.
Oh.
Okay, that is the restriction. So I'm not sure what you will be talking about, but in any event, I need to admonish you about that. All right, the first thing we need to do is we need to approve the agenda. Have we all called? Mike, have we looked at the agenda?
Move to approve?
Move to approve the agenda.
I'll second
Mike,
it.
you second that? Is there any discussion? Seeing none, the agenda is approved without objection. Next item, we're hurrying right along here. There are a couple minutes of prior meetings that need to be approved, and you were sent drafts of those, and I'm talking specifically about minutes for meetings of November 8, 2023 and December 6, 2023. Have we all had an opportunity to look at those minutes? Any
Yes.
objections, any corrections, deletions, changes? Move to approve?
Yeah, I wasn't here in November, but I have no reason to have any problems with it. And December I approved too, so.
Okay, all right, so you make a motion to approve, and
Second.
Carl, you will second that. Any discussion? Seeing none, those minutes are approved. Then we come to new business, and that is really the main issue of what we will be discussing today, and that's the Board of Adjustment hearing on appeal number 2023-01, in Ray Planning Board case number S12713, Mill Subdivision Tracts A, B, and C. Before we get into the substantive part of that appeal, I need to ask, just to be sure, are there any potential conflicts of interest that any board member may have?
No.
Mr. Probst, any conflict that you're aware of?
Not that I'm aware of, no.
Mr. Rose?
No
any
conflict. No conflict.
And I have no conflict either. So, we now need to consider the appeal. This was brought to the Board of Adjustment by way of the appeal by, and I will give you the names because I wrote it down someplace here, isn't that good? I can't, Robert Brown, Bonnie Kudnahowski, and I'm sorry if I meant to pronounce your name because I know how difficult names can be, and Carol Ashlock. They appealed the decision of the planning board to grant or approve a preliminary plat subject to conditions and plat notes, et cetera, et cetera.
Mr. Gucho,
Yes,
this is Tom Meacham. I would like to register at the outset my protest because the notice of the meeting of today was, in my opinion, superseded by a notice of December 26th, stated that the meeting would take place on February 13, 2024. And that's the last information I had representing the appellants as to when the Board of Adjustment would meet.
Okay, your objection is noted. We now proceed
Aye.
with the matter, okay? We have, the matter has been briefed by the appellants and by the appellee. The appellant filed a reply brief. You have received a confidential bench memo prepared by our counsel. And the matter is now at issue and we need to discuss the appeal. It appears to me that there are three issues that we need to discuss. Perhaps, depending on where things go. Clearly, the most important issue is the allegation and by the appellants and really agreed to by the appellee that a particular item that was to be included in the record was not included. Both parties seem to agree to that. And so the very first issue is whether the failure to include that item, and it is in both briefs, it is called the Falsey letter. And so we will refer to it here as the Falsey letter, please. That the failure to include that was a violation of code. And in order to bring this matter forward, neither one of you have been involved in matters that I've handled for a number of years. I like to have positive motions first so that we can then discuss the matter properly and so that it is before us. So what I mean by positive motion is that by the time you vote on the motion, you simply vote approve or disapprove the motion, okay? So by way of example, to bring this issue of the Falsey letter omission to the fore, the motion should be that the omission of the Falsey letter challenging the validity of a section line easement from the information provided to the planning board was a procedural error. And so I would entertain a motion accordingly. And Mr. Probst made the motion, and Mr. Rose, are you going to second that?
Yes.
Thank you. So, Mr. Probst, would you speak to the motion, please, first? You're the one who raised the motion.
Well,
If you're not prepared to do it, just say so and we just move on from there.
I'll speak to anything, thank you. But
Okay.
this seems to be the crux of the matter, why we're here today. And not for this meeting, but for a prior meeting, I had the Tom Meachin analysis that was part of the Falsey letter. And read that thoroughly and tended to agree with that, and then understood that that should have been part of the packet for the planning board, but for whatever reason was not. So, being the non-lawyer on this panel, it seems fairly straightforward to me that that should have been considered by them, and that it's our job to catch things like that and to weigh in on them. So that's where I'm coming from.
Okay. Well, let me ask you this. The issue is whether the omission of that letter, and it's admitted by both parties, whether that was a procedural error, yes or no, in your view.
In my view, it was a material procedural
We're
error.
not talking about material. We're only talking about, was it a procedural error, yes or
Sure.
no?
Yes, it was.
Okay. And so you would vote in favor of the motion.
Yes,
Is that correct?
that's correct.
Mr. Rose?
I would also vote in favor of the motion. I think that the code sets out pretty clear requirements for what information should be submitted for public comment for the planning board to listen to and review before making determinations. This fits within the four corners of what should have been submitted, and it wasn't submitted. Both parties agree it wasn't submitted. So I think it's a pretty clear procedural error.
Okay. Let me weigh in on this. First of all, whether the omission was a procedural error is a legal issue for determination by this board. And as such, this board must exercise its own independent judgment on that issue. If we conclude that it was an error, a procedural error, then the issue will then be whether that was a harmless error or material error. Okay. But we are first, right now, simply considering whether it was a procedural error, yes or no. I must tell you that, to my way of thinking, it's very clearly a procedural error. It was required to be included in the packet, and I'm referring to, and the citation there is in the code is 2103-020I. And the failure to include that clearly is an error, so I would vote in favor of the motion. Any further discussion on that issue? Seeing none, Madam Clerk, we want to vote.
Chair Guchow,
Yes?
Member Probst,
Yes.
Member Rose.
Yes.
That has passed 3-0.
Thank you. So having concluded that there was a procedural error, we then need to discuss, by way of really addressing a potential remedy, whether that error was material or whether it was harmless. And in order to bring that forward, I will entertain a motion, and that motion should be the error was harmless and not material. So that depending on how we vote on it, we either then come to the remedy or we conclude that no remedy is necessary on this issue. Okay? So I would entertain that motion.
Mr. Chair, I'll make the motion, but note I'm going to speak against it.
Okay. Mr. Rose?
Second.
Okay. Mr. Rose?
So the question then is the materiality of whether omitting the falsity letter makes a material difference in the decision. And I think this is ultimately the main decision we end up making today. My view of it is that the plating board is tasked with determining whether or not a plat as submitted to them should be approved within the confines of certain legal requirements. One of those legal requirements is that there's sufficient easements in place, right-of-way easements in place. It looked to me, as I reviewed the material, that the plating board concluded, without really finding and examining, that there was this section line easement on the appellant's side of the section line. And as I review the transcripts, as I review the record, the only information that that the board received at the board meeting they were making the determination, and with the packet, was the information coming from the appellee's representatives. Even when there's some discussion of section line easements, there's not reference to these other arguments. There's at least one board member during the planning board meeting that expressed hesitation. There's another member who asked some questions about section line easements. There was opportunity to have this discussion. And I'm left with the firm conviction that if it was before the planning board that there was a debate about whether or not this section line easement existed, that we may have an entirely different situation. They may not have approved the plat, and there may have been a different result. So those are my initial comments. I have more debate, but I don't want to take control of the entire forum right here. So I'll stop there.
Mr. Probst.
Yeah, I don't think I really have anything to add beyond what Michael said and what I said before.
So you would vote against the motion
Correct.
at this point?
Yes.
Well, let me weigh in here. The question is whether it's harmless error or substantial. If it is harmless, we just say it's harmless and we go on. If we come to the conclusion it was a material issue, then the question is what is the remedy that's available to this board? We can remand, we can, if we're unanimous, we can substitute our own judgment. But basically, those are the two alternatives that we're really facing here. The issue of the non-existence of the section line easement was brought up, as I read the transcript, was brought up by Rob Brown, he is the appellant. It was brought up by him. And so the discussion, and that was at the board meeting. So the board was aware that there was a dispute over the existence or non-existence of the section line easement. It's not, those of us who are lawyers may wish that it had been fleshed out better at this time. It was not, but it was mentioned. And so the planning board was aware that the petitioner asserted the existence of an easement and that the witness, Rob Brown, asserted there was no easement. The board chose to agree with the petitioner. And particularly, the view of the petitioner was based on a DNR analysis, and its own analysis, that is the S4 analysis, and the DNR analysis. And both of them came to the conclusion that there was no section line easement, but there was an RS 2477 easement that was on the east side of the section line. So the failure to include that, though raised at the meeting, did not, the board rejected that argument and simply relied on the view that there was an easement, and specifically an RS 2477 easement. It chose to believe the petitioner and not the opponents. So to my way of thinking, I have trouble finding that there was a material omission here, because the board was alerted to the omission. It could have done something, it chose not to. And so under those circumstances, I view this as really not material. And the Alaska Supreme Court has said, if there is, if an error, and we have already decided that there was an error, failure to include the Falsey letter, if it does not affect a substantive right, the error can be deemed harmless. Now, the reason that I also do not find that this is a material issue is because the existence or non-existence of a section line easement is not for the board of, for the planning board to decide. That's a legal issue. And both parties agree, and they stated it in their briefs, that the ultimate decider, so to speak, on the issue of the existence of existence or non-existence of an easement on the east side of the petition property is up to the courts. And so if the appellants feel particularly aggrieved they can go into court, into Superior Court, and have a determination made by the court over whether or not the easement actually exists or not. And it is for that reason that I view the error as not material, but simply harmless, because the remedy is preserved. The remedy is there. We do not need to decide what, if we come to the conclusion that this was a material error, then we need to decide what we're going to do about it. To my way of thinking, by concluding that this was a harmless error, we leave it up to the parties to get a final determination over whether or not the easement exists. And so for that reason, my position is that this is a harmless error and we simply move on. All right. Having said that, does that bring up additional, yes, Mr. Rose?
Thank you, Mr. Chair. So, starting with one of the last points you made, that this is a issue for the courts to sort out. I agree, and I think both parties agree, that neither the plating board nor this board can create the easement or sift through the historical data and find, for purposes of resolving the dispute between parties, that there's an easement. The problem that I have in the plating board's findings of fact is that they essentially do that with how they wrote their findings of fact. They find that there is a 33-foot section line easement, and I don't believe they have the authority to make that finding. And I'm also concerned at the inertia that creates if this were to end up being a quiet title lawsuit down the road, because the Superior Court has strong preferences to defer to the factual findings of administrative bodies. So because the plating board wrote their findings of fact in the way that found that this section line easement existed, I'm concerned that that may foreclose the appellants if they wanted to try and seek remedy through the court. If instead this body remanded or undid the plating board's decision, it would be an open question whether or not there's a section line easement. That would put the impetus on either party to file a quiet title action and to get the court's final opinion on whether that section line easement exists. So I think that the best course of action for this board to take, respecting the fact that this is a court decision, would be to not continue to allow inertia to build up where it already exists right here. And that ultimately, Mr. Chair, was where, as I was, because when I was doing my thinking on this, I had the same opinion that you just spoke to, but as I thought more about how this plays out in the future, that's the hang up that I get to. That's where I see that this error is material. It's not harmless because it does prevent that, the actual judicial finding of whether there is a section line easement or not. And I don't think, in terms of potential remedies that we might discuss today, I don't think it's appropriate for us to go through the historical data and try and determine whether or not there's a section line easement. 2 of the 3 of us are lawyers. None of us are judicial officers, though. And it ultimately is, I think, within the scope of the Superior Court to make that ultimate determination. Unfortunately, that means, litigation for the parties, but at the end of the day, I think that's the right course of action. So that's what I think. To the chair's other point about whether or not the omission of the Falsey letter was presented to the plating board, there is a very brief sentence or two from Mr. Brown's testimony where he references it. But reading that in the context of everything, I don't see that as presenting to the board that there's a legal dispute on whether or not a section line easement exists. Clearly, the information had been sent. The Falsey letter was originally sent in, and there's no references to that debate. Further, when the the representative, and I'm forgetting the gentleman's name, Mr. Callahan, is testifying. You know, the fair thing might have been to note to the planning board, hey, there's a separate opinion on whether or not this section line easement exists. But that wasn't what was presented from the professional, government agents and professionals that were presenting to the board. Essentially, they were hearing one side of the story. And I have to believe that if they heard the other side of the story, the debate or the inquiries or the decision might have been different.
Okay. So you maintain your position that you would vote against the motion?
Yes, Mr. Chair.
Mr. Probst, any further comments?
For clarification, the Falsey letter that we talk about, did that include the Tom Meacham analysis? Is that part of the Falsey letter?
I don't believe so.
I don't believe so either. I think the Meacham information came afterwards.
Yes.
Did it?
Yes.
Because when I read this back in November, it just seemed to me that
When you read what in November?
when I read the Tom Meacham analysis,
Okay.
for some reason now I'm thinking that was part of the Falsey letter, but I accept what you say that it wasn't. That strongly affected, my opinion of the case. And if that was supposed to have been made available to the planning board, but wasn't, I think that might have changed the planning board's decision on the plat or on the covenants on the plat. And so it seemed to be a fairly straightforward and narrow decision to me to have the planning board reconsider the matter with all the information before them. And then they could decide if they wanted to reaffirm their earlier decision or change it based on that.
I can speak to that.
Go ahead.
I think that thought makes sense, right? Well, let's say, let's just have the planning board review it again, but also get the information from the appellant side. The problem that I see with that is that puts the planning board in a judicial role of having to make the actual finding of whether or not the section line easement exists or not. And I think that both parties in this case agree in their briefing that the planning board doesn't have that authority. It seems to me the planning board has to rely on approving plats when there is definitively section line easement or right-of-way aspects are checked off and aren't being disputed. But when there's a dispute, and when it's a substantial dispute that requires deep investigation into historical documents, that's complex, and I do that as part of my practice. This sort of line. It's not as it is analytical. You can follow tests and definitions, and you can track what the analysis is to get the answer, but it's not simple stuff. That's why it has to be done, I think, by the court system.
But wouldn't,
Mr. Rose.
thank you, wouldn't the proper procedure then would be to present all the information to the planning board? They make their decision one way or the other, and then if somebody wants to appeal it, they appeal that to the courts.
No, that's not the way it would work. They
Okay.
would file an independent action to have the court determine whether the easement exists, yes, no. It would not involve approval of the plat or non-approval of the plat. Isn't that correct? Ms. Courtney?
That's
Pardon me,
correct.
please?
This
I'm sorry.
board is the agency entity that decides the goals from the planning board. A quiet title action would go to the Superior Court, but the Board of Adjustment must first decide this issue on appeal. And then if either party is aggrieved by that decision by the Board of Adjustment, then the Board of Adjustment's decision gets appealed to the Superior Court. A quiet title action would be separate from this appeal. And a quiet title would be the action to determine whether a section line easement exists or not.
Thank you.
My thinking is I continue to believe that this was a harmless error for the reasons that I stated. But aside from that, let us assume, arguendo, that we come to the conclusion this was a material error. What is the remedy? We have by ordinance, and I can get out Title 21 here, and will tell you what we can do. We can either remand or here. Right here it is, and I'm looking at 2103-050. 050, scope of review by this board, and it says 11.11 little b. The Board of this is on the legal issue. The Board of Adjustment shall, unless it substitutes its independent judgment pursuant to 11D below, defer to the judgment of the lower administrative body regarding factual issues. Findings of fact adopted expressly or by necessary implication by the lower administrative board may be considered as true if they are supported in the record by substantial evidence. The term substantial evidence for purpose of this section means relevant evidence as a reasonable mind might accept adequate, etc., etc. The Board of Adjustment may, by unanimous vote, substitute its independent judgment to that of the lower administrative body on any disputed issue of findings of fact. So we can either remand for consideration by the planning board, or we can, by unanimous vote, substitute our own judgment, change that. To my way of thinking, the only remedy would be, the only reasonable remedy in this case would be a remand. For the reasons stated by Mr. Woods. To my way of thinking, that would not accomplish a lot, because then you have the situation where the planning board will be confronted with two opinions. One of them that says there is a section line easement or an RS 2477 easement, and the other one that says no, there are no such easements. What is the board going to do at that point? They're just simply going to, well, it seems to me they have no choice but to reject the planning application, or the subdivision application. So we are not really resolving anything substantively. So to my way of thinking, the way to proceed simply is to say, this was a harmless error for the reasons that I previously stated. They were alerted to the fact that there was another opinion out there, and they chose not to go along with that argument. Instead, they relied on a DNR analysis and on an S4 analysis that there was such an easement. So, and as I said, anybody can really substantively appeal this, but it is really up to the appellants, it seems to me, that if we conclude that this was a harmless error, it is the appellants who then need to march into court and file the quiet title action. That would be the way that it would have to proceed. To my way of thinking, simply sending it back to the board for reconsideration does not resolve anything substantively. And it is for that reason that I would vote in favor of the motion that this was a harmless error. All right, does that raise any additional comments? Mr. Probst?
I'm not sure that it changes my mind, Mr. Chairman, but, you know, I am brand new on this commission, and I don't really know historically or traditionally speaking kind of how this commission works.
It's a board.
Thank you. So whether we tend to, are more inclined to make final decisions that can be appealed, like you're suggesting, or try to stick to the straight and narrow that seems to make sense to what Commissioner Rose and I are thinking of, and sending it back to the planning board, even though, like you argue, that might not change anything. But maybe that's more of a decision for the planning board to make than for this board to make. I just don't know because I'm so new on the board.
Let's come back, however, to the motion itself, and that is, the motion reads that the error was harmless and not material. Maybe I strayed too far by saying, what do we accomplish? Maybe I should not have said that, but in any event, I continue my position that I believe this was a harmless error that does not require any action by this board or by the planning board by way of further consideration. Is there anything further, Mr. Rose?
I did want to comment on one of the last points that you made, and it's of course it's on the assuming argument that we agree that this is not a harmless error. I think there's 2 points to make. One is that appropriate analytical decision making requires us to ask the question before we consider the ramifications of that. So that's what we're doing with how you kind of focus the issue questions in the order that we're doing it. That said, there was this question of, harmless, okay, if we just send it back, remand it to the planning board, they're forced with 2 competing opinions, they can make the decision, they reject it. If that's the right result, then that's the right result. And I think what this board's obligation is to make sure that the planning board is operating the way that the law says that they should operate. And if they're only permitted to approve platting proposals that with all of the rights of way and legal requirements done, and they have a planning proposal that comes to them, and there's a significant dispute between the two, and they're not the judicial body that can make that determination, they shouldn't be making that determination. And where I come down on it is they did make that determination. This isn't us deciding whether or not the factual finding of there is a 33-foot section line easement on the appellant's side of the section line is a factual finding that we should uphold or not. On that, I think the law is clear that we have to give deference on actual factual findings. The issue that I take is that the planning board shouldn't have been making that factual finding. That's a judicial finding that they should have recused, not dove into and just made their opinion and their finding without the authority to do so. That's a legal error for them to make that factual finding. So the dispute that I have is not so much with the factual finding itself. because we have to give deference to factual findings unless we unanimously agree we're gonna substitute our judgment. And I do stress, we shouldn't. I mean, the three of us don't have the judicial expertise to dive into the historical data and be able to make that factual finding of whether there's a 33-foot section line easement or not when there's a dispute. Neither does the planning board. It should be a court that decides that, and for that reason, the planning board should have rejected this this proposed plat. It should have required the petitioner to seek quiet title to establish that there was an easement, and then bring that to the planning board. So one way or another, it's going to have to go to the court. I think what we're tasked with is doing it the right way. I think I've said my piece on that. So, thank you, Mr. Chair, for
No problem. Mr. Probst, anything further?
Nothing more.
In this matter? All right. Madam Clerk, would you call the roll on the vote?
Chair Guchow,
Yes?
Member Probst,
No.
Member Rose,
no.
And the motion fails by a vote of 2 to 1. All right, having then concluded that there was a material error, the next question is the remedy. And as I said before, and maybe Ms. Kitchen, you can help me out. There is a section in the code that tells us that we can either remand or we can substitute our own judgment, or we can make changes to the decision of the planning board, and I would like you to give me a citation to that first. Just a moment, please.
Certainly.
Yes.
In other words, it's as to the remedy at this point that we are talking about.
Okay, if the board, which it has found that a material error occurred, it can remand the matter to the planning board if the error requires further public hearing, and that is under AMC 2103 050 A13 little a II.
Okay.
Alternatively, Anchorage Municipal Code 2103 050 A12A permits this board by a majority vote to modify the planning board's decision in whole or in part, if that modification can finally dispose of the case on appeal. On appeal to this board, we're not talking about.
Yes.
Does that answer your question, Chair?
Well, there's the third alternative, isn't there?
With
So we
substitute.
can modify,
Mhm.
we can remand, and we can, the substitution of our own judgment, that's what gets me, because it requires a 3-0 decision. But the decision to modify is not a 3-0 decision, is it?
Correct.
Okay,
Majority.
that's, all right. So flesh out the third alternative, the substitution of our own judgment. Here, and I'm looking at it right now. It's 210305 11D. The Board of Adjustment may, by unanimous vote, substitute its independent judgment for that of the lower administrative body on any disputed issue or findings of fact. Such judgment must be supported on the record by substantial evidence. Okay. So there are 3 alternatives that we have. We can either send it back, we can make modifications to the decision of the planning board, to the resolution that we have all looked at, or we can, by unanimous vote, substitute our own judgment. And that presumably concerns the existence or non-existence of the section 1E. To my way of thinking, I must tell you, I'm hesitant to substitute our own judgment in this case because it would put us in the shoes of a court who makes the decision over the existence or non-existence of the section line easement, and I don't think we should do that. So, to my way of thinking, it comes down to either a remand or modifying the decision by the planning. Those are the two alternatives that we, I think, have. Now, there's no motion on the floor at present, but Mr. Rose, you wanted to address us here.
I want to make a motion.
All right.
Following your leadership of how you want to move this forward.
Yes.
I would move to remand the case to the planning board with instructions to reject the plat if there is a substantial dispute as to the existence of the section line easement. Thereby instructing the parties to seek redress in court.
Okay.
I'll second that.
Mr. Rose, would you address the motion?
The reason I phrased the motion the way that I did is it still gives the planning board the final action here, which should then lead very easily into court action to determine it. We are still hearing everything secondhand. As well as good as the record is, it's still the planning board's determination to hear things firsthand. But I do think that there's a significant dispute as to the existence of that easement, that the planning board's instruction should be to reject it.
To reject, help me out, because
to reject the plat from to reject the mill subdivision plat. As not having the necessary requirements of that right of way.
Okay. So that would fall within the section of the code that talks about remand, and I'm looking at 2103-050-13. The case shall be remanded to the lower body where the Board of Adjustment determines any of the following. Little I, there's insufficient evidence in the record on any issue material to the decision of the case. Double I, there has been a substantial procedural error that requires further public hearing. Or 3, triple I, the lower administrative body has made a legal error that in the opinion of the Board of Adjustment warrants a remand. And I would like you to specifically in your motion address those 3 alternatives for a remand. Mr. Rose.
Yes, so little 2I and little 3I are both implicated with the situation that we have presented before us. Starting with little 3I, which is what this motion is geared towards. I view the planning board making a factual finding that a section line easement exists when that's a judicial conclusion of law that needs to be made to be a legal error that was committed by the planning board. Separately, I also believe that the little 2I, I don't have it in front of me, I'm sorry.
Yes, I have it here if you would like to.
Thank you, Mr. Chair. Separately, I think we voted that there is a material procedural error that occurred in front of the planning board. The concern I have, and the reason that I phrased the motion the way that I did, is if we just remand with instructions to have more public hearing, and the planning board has more public hearing, and they make the same legal error that they just made before, then we're hearing this case again in, 6 to 9 months or something. So that doesn't help move this thing to a conclusion. I think both of you want is to move this thing to a conclusion. I think that conclusion has to happen, at the Nesbitt courthouse.
Mr. Probst, any thoughts? I'm not trying to put pressure on you.
No.
If you're still on the fence, as it were, that's fine.
No, I'm not
Because
feeling.
I have some comments to make too.
I'm not feeling any pressure. It seems like the choice to remand or modify or come to a unanimous decision. You can parse it, but to me, it really comes down to remand or come to a decision. And when faced with those alternatives, I think this belongs before the planning board and not us, so I'm in favor of remanding it.
All right, well, let me weigh in for a second here because I seem to be the person who takes a contrary view. I am in favor of modifying the decision of the planning board. And specifically, what I'm looking at, and you have the decision of the planning board in front of you, specifically simply deleting A3. And A3 of the findings of fact state as follows: the finding from the Alaska Department of Natural Resources submitted with the application have confirmed the presence of a 33-foot wide section line easement directly abutting the eastern boundary of the subdivision. The dedication of a 25-foot right-of-way extension along the existing alignment of Bonnie Lane Road within the subdivision boundary will provide a total width of 58 feet available for the future construction of Bonnie Lane Road. My thought is that we should modify the decision of the planning board by simply deleting that paragraph. And by deleting that paragraph, we leave in place finding number 7 of the planning board. And 8, because if we leave in place number 7 already says the petitioners exercising their legal right to subdivide their property in a manner compliant with Anchorage Municipal Code. The municipal code requires legal access and physical access to the subdivision. So we would simply leave that finding in place. But we would delete the specific reference to the finding of the DNR analysis is the one that really should carry the day here in terms of the existence or non-existence of this easement. By way, if we were to do this, and simply delete finding number 3 but leave in place the others, we would accomplish what Mr. Rose previously referred to, which is not give a superior court or any other court or create an unfair advantage to the petitioner in subsequent litigation to quiet title. And by way of deleting, or as a consequence of deleting this, I think we are leveling the playing field here. And I would like to do that because a remand will cause the delay that Mr. Rose has already spoken about. It's entirely possible that the case would again appear here. By deleting paragraph 3 and simply making this a final decision, we are telling the parties that the next step is that they need to appeal this board's decision. Alternatively, they can litigate a quiet title action. So to my way of thinking, simply remanding it as Mr. Rose wants us to do by way of his motion and directing the board that they should really dismiss the plat application, I don't think we're really accomplishing a whole lot. I would rather like to see a final decision by this board which affirms, in a way, the planning board's decision and let the parties exercise their legal rights at that point. Having said that, Mr. Rose.
Thank you, Mr. Chair. Does deleting paragraph 3, and this is kind of an open question for us to discuss, would deleting paragraph 3 lead to the conclusion that the plat doesn't have a sufficient enough right-of-way on that side for legal and physical access? I believe that the petition was hinged on this 33-foot section line easement in order to have sufficient right-of-way access. So I guess my question, and if this is the case, my concern is that by deleting this paragraph, aren't we making the findings that the plat is approved inconsistent with the code?
I don't think so, because finding number 7 says they are subdividing their property, quote, in a manner compliant with Anchorage Municipal Code. And municipal code requires legal and physical access. But it eliminates any reference to the DNR finding on which they based it. And your previous argument had been, by leaving that reference in to the DNR finding, you're really prejudicing any subsequent quiet title action subsequently.
No, I agree, and I appreciate that. And what I'm trying to figure out, and maybe this is a question that I don't know without re-looking at the code, is a 25-foot setback right-of-way easement, the 25 feet that's in the plat, if that alone were the platting application, is that enough of a legal basis where the platting board would have said that's enough legal and physical access to the property? Or is there something in the code that says you need more than 25 feet, and that's why the petitioner needed to have this section line easement?
And the answer is yes.
Okay.
The answer to that is yes. In other words, the code requires, I can't remember, is it 50 feet or 60 feet or something like that?
50 to 60 feet.
Right.
So it doesn't work
Right.
unless both of them are in existence, i.e. both the section line easement and a dedication of an additional easement on the petitioner's property.
Right.
So
So the petition, the plat, for it to be a valid plat that should be approved, needs to have at least 50 feet.
absolutely.
Okay.
Yes, that's
So
true.
by just deleting paragraph 3, but keeping everything else in the decision the planning board makes, the planning board's decision is this plat's approved. But that's got an inherent error in it because the only right-of-way is 25 feet on the eastern part of the property. And we want to put our stamp of approval on that decision. I don't think that we can. I think the planning board can't. That's not an approved plat, right? That's it. Paragraph 7 doesn't say that, any future subdivision of the property has to include additional easements, right? It just says this plat is approved, and all the plat has on it is 25 feet of right-of-way easement on the side. So if we eliminate or paragraph 3, we have a plat that is internally not valid. It's a creative option. It's an interesting point to leave paragraph 3, but I don't know that it works.
You don't think it works? Let's ask our esteemed counsel here what she thinks about this.
Respectfully, I'm going to agree with Member Rose that the plat, according to code requirements, and I can bring up those code requirements, has to be, it's deemed, let me get to this, so I say it correctly. The Mills subdivision implicates two streets, Bonnie Lane Road and East 140th Ave, and both are considered local streets, and code requires a minimum right-of-way width of 50 to 60 feet for those. And here, the application achieves that width requirement for Bonnie Lane Road through the 25-foot right-of-way dedication shown on the preliminary plat, combined with the 33-foot section line easement directly abutting the eastern boundary of the subdivision. So code compliance for Bonnie Lane Road's width therefore relies on that 33-foot wide section line easement existing.
So if we were, so what you're really saying is, and what Mr. Rose is saying, if we were to eliminate simply finding number 3, that would leave an inherently defective situation in place.
And I think about it this way, if the plating, let's pretend that paragraph 3 didn't exist.
Yes.
Let's pretend that decision was before us. We would have to remand that as an inappropriate plat that the plating board approved because it only had 25 feet as a right of way, right? Because they can only approve proper plats if there was a dispute about whether or not that was sufficient. So I like the creativity in deleting that, but I don't, as I kind of puzzle through the dilemma, I don't really, and maybe there's another creative solution we can come up with. I'm all open for discussing creative solutions, but I don't see another solution that presents itself other than forcing this to a point where it has to go in front of the court, and going in front of the court without either party being advantaged by the benefit of a factual finding in inertia.
So, Madam Clerk, would you read the motion that Mr. Rose made? If you can do it, otherwise we simply
I didn't write it down.
State his
verbatim
motion.
either.
Chair?
Yes.
Michelle, can I just make one point that maybe the board would want to consider
Yeah,
as
please.
well? And, you know, this is for the board to consider, but because you can modify the decision and there are plat notes that you can place on the plat, you could place a plat note, you could require a plat note that the subdivision must comply with street width requirements. And then at that point, that would leave the street width requirement and the section line easement issue up for the court system to address. And I can get you that, that code section if you would like, the code section that addresses that.
The code section regarding the width,
Mhm.
that should be easy to find. Anyway, Mr. Probst.
Along the same lines, it seems to me that the code requires 50 to 60 feet. There's a 25-foot right-of-way. There may or may not be a 33-foot section line easement to get that 50 to 60 feet. Why doesn't the planning board or us just say there should be a dedicated 50, 55, 60-foot wide right-of-way? It may or may not include a 33-foot section line easement. We can't decide on that, but we understand that to be compliant with the code, you have to have this width.
Yes, and that's what Ms. Kitchen just addressed.
Right.
Basically. It seems to me that if we were to do that, that means, in practical terms, we delete finding number 3 and add a condition. Not a plat note, simply a condition. There are already a bunch of conditions here that have been imposed, and that's paragraph capital B of the planning board's decision. That we add one at the end And there's all kinds of renumbering issues here that would have to be corrected, but basically saying the right-of-way, or legal access, legal and physical access need to comply with code, basically. What would be wrong with that? Because at that point, we finalize the decision and we let the parties decide whether or not there is an easement, in which case nothing else needs to be done, or they agree there is no easement here, and then it means that the petitioners need to grant, in addition to the 25 feet that they have already agreed to, they need to give another 25 feet or 30 feet or whatever it is.
Right, well, that would be another solution for a petitioner if they so chose, right?
Yes.
They could decide to just
Exactly.
do a 50-foot right-of-way easement on their side of the line. But that would then give the petitioner the choice. And I don't know, that may not be even a palatable option, but that's for them to figure out. I might be coming around to this idea of deleting finding 3 and reworking. I think some of the internal references have to be reworked as well.
Yes.
You know, the paragraph 8 specifically refers to
Yes, it
right-of-way.
would have to
So
be
we have to kind of
modified as well.
rework some of it.
And there's a numbering issue while you're at it, I'm sorry to
Yeah.
interrupt, but there's a numbering issue here that we've got to clean up as well.
What about a finding that says this board makes no decision on whether or not a section line easement exists? Just making it a clear statement that that is an open question, that this document forevermore should not be presumed to interpret that a section line easement either exists or does not exist. Because as we're talking about this, I recognize my concern in establishing inertia for the parties in Superior Court. I don't want to overstep that. I don't want to go too far and to create inertia for the other side, right? I think the goal here is to say, we're not the body that needs to be making a decision. The court needs to be making a decision. So maybe a finding that says, we express no ultimate opinion on whether or not a section line easement exists, and that's best left open for the court. Whether that's a condition, whether that's a conclusion that's in the first handful of paragraphs, I don't know.
Okay, that would require a total reworking of the planning board's decision, because then we are talking about deleting number 3. We are talking about changing number 7. We're talking about changing number 8, you know, the additional findings. And essentially coming up with our own findings. And the question is, and Mr. Probst addressed that before, that he is hesitant to have us do that and take on the role of the planning board here. That's really what we were going to do if we were to go along with the suggestion that you know, both Mr. Rose and I were kind of working towards here.
Yeah.
I'm not sure. What is your thought, Ms. Kitchen?
That's a decision for the board.
That's for all the world to have.
No,
That's
we
my
are not
client's
asking
decision.
you to make a decision, we are asking you to give us your thoughts on this.
Well, as you noted earlier, the board can modify the decision by a majority vote or substitute its independent judgment by a unanimous vote.
Thank you. Well, we're really.
But Mr. Chair, you know that you and I have given answers to clients like that.
Oh, of course.
So.
So we are really in a quandary here, and the question is, what's the will of the body? There is a pending motion on the floor right now, and we have discussed it. If we are still faced with the alternative, really, of approving that motion, in which case, and you will need to read it back to us, or maybe the clerk can read it back to us, so that we firmly have this in front of us, what we are voting on, because there was an instruction there, and I'm concerned about the wording of the instruction. So maybe we can have that motion. Madam Clerk, can you
Through the
read?
chair, I think I have it, but
Okay.
can you help me clarify if it's incorrect? So move to remand the case to the planning board with the instruction for the consideration of the section line easement. Was that it, or was there more?
Mr.
I,
Rose?
I have it written down if,
Okay,
Oh.
it was, move to remand the case with instructions to the planning board to reject the plat if there is substantial dispute about the substantial dispute about the section line easement.
Okay. Mr. Rose, does that reflect?
it does, Mr. Chair. I think we'd benefit from more discussion before we vote, though, just in case you were, I don't know if you were just road mapping us back to it or teeing up a vote. But I think we have to discuss a little bit more. That's okay.
Well, go ahead, discuss more.
Not to speak against my own motion, but I didn't really flush out the detail of what substantial dispute between, about whether a section line easement exists or not. And I am a little concerned that without clear direction, the planning board, one, might not know what to do with that, and two, it may just create, more difficulty. So, as this alternative of reworking the findings of fact that we're talking about, that may be a better approach to get to the same conclusion. I guess my mind's not, my mind's not made up yet.
Okay. Mr. Probst, any thoughts on the matter?
Obviously, I'm flip-flopping back and forth here.
No, that's fine. We are in the discussion stage.
On the one hand, I like keeping it simple, just remanding, letting them make the decision. On the other hand, if we can, all three of us, come to a conclusion, solution that we think makes sense, I'm open to that now, I guess, where I wasn't before.
Well, the difficulty is that if we modify it in the method that I initially suggested, we will finalize the case. That would be it. And that there's an advantage to that. Because when we have the written decision, the party has 30 days to appeal to Superior Court the decision of this body. Okay? So it moves the case forward. On the other hand, if we gum it up to such an extent that we're really not accomplishing a thing here, that's not good either. And so perhaps the issue is to simply send it back, not try to make amendments here to the planning board. Remember, those people they're experienced people. They have done this for a long time. This is not the first plat that they've been confronted with. And who are we really to put ourselves into their shoes here? Maybe the answer is we should not do that. But we should send it back with instructions to revisit and perhaps reopen the public hearing regarding this case. And revisit the case in the light of the conflicting opinions of whether or not an easement exists. And simply put the burden on the planning board at that point. Clearly, this cannot be the first case where there has been an issue over the existence or non-existence of a section line easement that controls the viability of a proposed plat. And it also would put the petitioner in a position that may be having to rethink the situation. So maybe that's a better way of going here. And what that would then mean is that rather than the motion that is on the floor right now, that we simply remand it for public hearing with, or that we remand it with instructions to consider the effect of the faulty letter. Simply leave it at that, because that's the objection that the appellants have here. And let the parties battle it out, and let the board make a decision on the basis of that battle. Maybe that's a better way of doing it. Yes, Mr. Probst.
The simplicity and logic of that appeals to me. I mean, that's how,
Okay.
when I came into this meeting.
Yes,
But the argument that you make, that delays the process, doesn't appeal to me as much. So,
well, I can tell you that a quiet title action would take some time also. And I think, if I'm not mistaken, I think we have here appellants who are pretty determined to push their views. And so I would think that there's an inevitability here of subsequent litigation anyway. So try as we might, we cannot conclude this case. That's, I think, where all of us, I think, come out. Isn't that true, Mr. Rose?
I think so. I think short of making the determination ourselves, I don't think that we resolve the entire dispute. I think we've talked through the difficulties in reworking some of these parts of the decision, deleting paragraphs, modifying paragraphs, whatnot. I worry, technically each one of those changes is a modification. It might be a modification of a finding of fact. It might be a modification of a conclusion, like a legal conclusion. There's a requirement that each of those changes on the findings of fact that we do has to be unanimous vote for us to substitute our judgment for it. And we may not be in the best position to go through all of that. Remanding the matter back to the planning board with the instruction to consider the debate of whether or not a section line easement exists as per the Falsey letter and the arguments from the appellants. And permitting public hearing on that would force a decision to the planning board whether or not they feel comfortable with their experience of finding that a section line easement exists. And if that really is a judicial finding, like both parties argue in their briefs to us, the planning board should elect not to make that finding, and should reject the plat and force the parties to go to Superior Court. So that is the end result. If the planning board agrees that it can't make a judicial determination on the section line easement, only if they reopen it for public hearing, have public hearing, debate it out, decide there is or is not a section line easement. After the benefit of that, do they make the finding? And at that point, theoretically, the parties have had their due process in being able to argue fully their positions on the issue. And I feel less concerned about the inertia that factual finding would generate in the Superior Court. I think at least at one point or another, Mr. Chair, we've swapped opinions on these motions. But that's the benefit of the discussion, right? So I think may I still rescind my motion so we can?
Well, yeah, but before we go there.
Okay.
That's a yes.
Okay.
The answer is yes to that.
Okay.
But I would like to wait for that because I'm looking at the remand section.
Okay.
That allows us to remand. And I think at this point, I think all three of us would feel comfortable with a remand of some kind. I'm coming around to that, I must say. The question then is, I'm looking at the remand section, and there's 2103-050 A13A, little I, double I, and triple I, and that is basically we can remand when we determine the following. One, there's insufficient evidence on the record on an issue material to the decision of the case. Two, there has been a substantial procedural error that requires further public hearing. Or three, the lower administrative body has made a legal error that in the opinion of the Board of Adjustment warrants a remand. And I'm tending towards number three, the one that I just read. The lower administrative body has made a legal error, and that is finding that there is an easement. Or do we want to say that?
That was my initial take on it too, when you pulled those out. We talked about that a few minutes ago. It might be appropriate in the kind of decision tree that we have.
Yeah.
For us to, instead of the large motion that I just made, to have a smaller motion that says that we vote to remand based on that little I3. And then we can have a separate discussion about what the instructions look like of what that remand looks like. So if we parse it out into different pieces, we may be able to move along. Because I think you're right. I think we all take the temperature. Seems to be a remand in the cards.
Yes, I think we are gravitating towards that. But then there is alternative number two, double I. There has been a substantial procedural error, and remember we already found that, that requires further public hearing.
Yeah.
And
I'm sorry, go ahead.
and simply leave it at that, and as part of our findings here, we say there is a problem. The procedural error is that you did not consider the faulty letter. Okay? You need to consider the faulty letter. You can eventually come to the same conclusion, but you at least need to consider it properly. So that would be, yes, Mr. Probst.
To weigh in, as the non-lawyer in the group, I'm a little awkward at finding that there's a substantial legal error or omission, or however it's worded. I'm more comfortable at finding that there's a procedural error. So maybe you want to cite both if we have to cite either.
And I don't know that we need to cite only one. These are just, as I understand them, and maybe Ms. Kitchen can chime in too, but my understanding is these are the three different bases for remands. Mm-hmm. If we make the decision to remand, then we can decide what that remand looks like, no matter which of the three bases we use out of these three subsections.
Correct.
Ms. Kitchen?
I would agree with Mr. Rose's assessment of the code. You can remand based on any of those three.
All right.
So I would suggest we actually state multiple bases if there are. I mean, the same reason that any court ever gives multiple bases for their decision. If there are multiple bases for the decision, we should state them all.
If we want to.
If we want to. we have to vote on each one, obviously, and discuss each one. But if there are multiple bases, we should make sure the record's clear on it.
All right, so then let me recap where I think we're gravitating towards, and that is the remand. And if that is the case, then the motion should be amended to delete the, to simply say we remand this to the Board of Adjustment. To the board, to the planning board, I'm so sorry. And leave out the portion that you added with instruction to it, et cetera, et cetera. If we were to do that, then we need to make a separate motion. Let's assume, for argument's sake, that we agree to approve a motion that simply remands the matter to the planning board. Then the next question is, on what grounds, or for what purpose, as specified here in the section that I read, do we do that? Because that's the further instruction to the planning board, in all fairness. Does that make sense?
Yes.
All right. So, I will move to amend the pending motion to simply read, this case is remanded to the planning board for further consideration. And leave it at that. Could I have a second on that?
I can second that. We're gonna then discuss what the instructions are. So yeah, I can second that.
Okay. My thinking is that by voting on the motion as amended, and this is an amendment to the pending motion.
Right.
By doing this, we are then in a position, assuming that passes, we are then in a position to say, to determine why we are remanding it. And there are the three alternatives here.
And actually, as a point of order, Mr. Chair, since the pending motion was my motion,
Yes,
I can accept your amendments as friendly.
Okay, well, thank
So
you.
I'm just accepting that becomes.
good. All right, so there we are. Any further discussions regarding this? Are we all on board here? I think, I have no further comments. Mr. Probst, do you have any?
I'm good.
I call the
Mr. Rose?
question on the motion
All
as
right.
amended.
All right, Madam Clerk, would you call the roll on the vote?
Chair Guchow,
Yes?
Member Probst,
Yes.
Member Rose,
Yes.
Thank you, and the motion passes. So now we need to discuss why we are remanding it back. And remember, the alternatives are, there is insufficient evidence in the record on an issue material to the decision of the case. 2, there has been a substantial procedural error that requires further public hearing. Or 3, the lower administrative body has made a legal error that, in the opinion of the Board of Adjustment, warrants a remand. To my way of thinking, it is either 2 or 3. It is a substantial procedural error that requires further public hearing. Or number 3, the planning board has made a legal error that, in the opinion of the Board of Adjustment, warrants a remand. And before we make a motion, I would like to have a little bit more discussion on that. Mr. Rose, you had previously looked at this and talked about it. I think number 2 clearly applies. A substantial procedural error has occurred that requires further public hearing. That much is clear, because at a public hearing, presumably, the appellants, or either one of them or somebody else, will bring up the falsy letter again, together with the opinion that had previously been done by somebody that there's no easement. So number 2 clearly applies. Then the question is, was the planning board's decision a legal error that, in the opinion of the Board of Adjustment, warrants a remand? And I think the answer is no. They didn't make, did they make a legal error? I don't, no, it was an error of finding a fact.
Is an error in making a finding of fact that is outside the scope of what you are permitted to make itself a legal error?
Oh.
Right, so for instance, I'm
Yeah.
a litigation attorney, right? There's district court and there's superior court in our state court system. The jurisdiction's different for each one, right? Cases that have over $100,000 in amount of controversy have to be in the superior court. They can't be in the district court. If the district court makes a finding of fact and fines for the plaintiff in the amount of $1 million, that's a legal error because the district court doesn't have the legal authority to make that finding of fact. That's the argument that I'm saying happened here with the planning board. By making a finding of fact that both parties in their briefing suggest they don't have the authority to make, right? So yes, it is nestled in their factual findings, but the very point that they make that finding, I view as a legal error. And that's kind of the analysis that I use to help that make sense.
But the problem with that argument is that every plat that is being proposed needs to comply with municipal code. So there has to be a finding that there's legal and that there's legal access and street access. So what you're then saying is that that's a, do you jeopardize future plat applications?
That's a fair question. I think there's a difference between looking at a plat that has a 25-foot easement and comparing that to the law that says there needs to be 50 to 60 feet. You can make a factual finding that there's only a 25-foot easement, so it doesn't meet the law, and we're going to reject this plat, right? That's a different sort of analysis than there's a dispute among parties of whether or not this easement exists. I'm going to conclude that this 33-foot section line easement exists.
Okay.
So I think there's a distinction between those types of decisions, and I would not want this to hamstring the planning board to do what they have to do, but I think they've usurped a little bit of the judicial role in what they did in this particular case. And that's where I think some clarity from us in pointing that out is important. If we just remand for the procedural error on the Falsey letter and we don't also remand on this legal issue, I'm worried that then goes potentially missed. So my position on it, at least right now, is that both, subsection 2 and subsection 3 of the remand sections that we're talking about apply.
Okay. My druthers would be that we simply remand for further public hearing, and that, remember, we need to justify our decision. And the justification is findings of fact and conclusions of law, which then leads to the order to remand. Okay? That we simply address our concerns in the findings and conclusions. And that the order that we craft and agree to simply says it's remanded for further public hearing. And here's the reason why we are doing this. Our own findings of fact and conclusion. Rather than getting into the morass of stating that they have made a legal error, I would like to stay out of that. And simply say you have made a procedural error and here's our concern, as expressed in our findings and conclusions. Yes, Mr. Probst.
I agree, but at the same time, I don't think we want to remand anything back without giving planning board, you know, the full benefit of all of our kind of give and take and thoughts on this. We don't want to shortchange them when they consider this again. So wherever we put it, you know, we should let them know.
You're all concerned.
Yes.
Well, as I said, the way to do that is to put that in our findings and conclusions. Here is why we are remanding. And simply express the concerns that, you know, we have now voiced here for quite some time. How does that sit with you, Mr. Rose?
I have to think about it a little bit more. I'm sorry.
Okay.
I'm sorry. Some I have these moments. My wife knows it too. I have these moments where I just need to digest and think.
All
So
right.
I'm at that moment.
In any event, while you're, yes, Ms. Kitchen.
I'm just gonna chime in here and say that in the findings and conclusions, I think what Chair Kutzschau is suggesting is that in the findings state that there is a dispute about the section line easement. The authority to determine whether a section line easement exists is with the court system. There was a procedural error because the faulty letter was not considered. The plat must comply with street width requirements. Remand further to determine whether this plat complies with street width requirements. Is that
Yeah.
summing up what some of the findings would be?
I mean, I'd be perfectly fine if there's also value in, and I think most boards do this, value in coming to a consensus final decision. So I think talking this out is helpful. If there's some hesitation on that subsection 3 legal error, but we all seem to have agreement at least there was a vote for substantial procedural error, and that seems to be sufficient grounds to remand. So long as those findings and fact and conclusions of law that we draft out do reference the fact that there is a concern that this should be ultimately a judicial finding. If there is a dispute, I think that achieves the right, the just result today.
All right, then let me ask our esteemed counsel, rather than directing the board to reconsider because of the omission of the faulty letter, we simply say, there was a procedural error here. You didn't have all the evidence or all the material in front of you that you should have had. And here are our findings that lead us to this. And here are the conclusions. We need you to reconsider this in the light of the fact that there is a dispute over the existence or non-existence of the easement. And simply leave it at that. Because at that point, we're putting the monkey squarely on the planning board to either come to the conclusion or reaffirm the conclusion there is an easement, or say, we're just like, we're like the Board of Adjustment, we don't know whether there is or isn't. And so we can go forward with a plat.
Chair Kuchel, I
Yes.
would suggest that the planning board could, as we have discussed here, you have discussed here, they could put a condition on the plat that it must comply with street width. And then that again ensures that there's compliance with code and allows the parties to pursue any judicial order regarding the existence of a section line. Or it also permits the petitioners to adjust, as Mr. Rose has said, adjust their petition to include a 50-foot wide right-of-way easement within their plat. So I do think it gives them some latitude, and we can put into our findings and conclusions the concerns that were
Because there is a
expressed here.
question over whether or not the right street width demanded by code exists.
Yes.
and simply leave it at that. By way of finding and conclusions here by this board, and remand it for further consideration.
Just a point of information question. The findings of fact and conclusions of all that we're talking about procedurally, how do we go about getting those drafted, reviewed?
Well, here's the way it works. Ms. Kitchen will draft a proposed order, and she will send it to me, and I review it, and if I have substantial questions, I will get on the phone and I will say, hey, here are substantial questions. Or alternatively, I will say, yeah, you did it just right. And that's what our second meeting is about. Because at that point, we need to approve it, and remember what we are deciding, there needs to be findings of fact, conclusions of law, and an order. Okay. Those three, or judgment. Those three items are required of us. And so our concerns would be contained in both the findings and the conclusion. Okay? I hope I stated this correctly, Ms. Kitchen?
Yes.
Thank you. All right. Are we so far on board?
Mhm.
Okay. So what we have at present is a motion on the floor that simply remands the decision of the planning board back to the planning board. And then the question is, do we want to state it is remanded because there has been a substantial procedural error that requires further public hearing? Yes, Mr. Bowles.
I would move that we remand for that reason listed in section 2. That there be a substantial error.
And I think, Mr. Probst, you were the second.
I'll second.
All right. And you agreed to that amended motion? Okay. All right. Is there further discussion? I think we've come to the conclusion as to how we want to do this.
I'd call the question. I think that we
All
are
right.
pretty good.
Madam Clerk, we are ready to vote.
Chair Gachow,
Yes.
Member Probst,
Yes.
Member Rose,
Yes.
And the motion passes 3-0. So, having now concluded that the matter needs to be remanded, the additional issues really go by the wayside, isn't that right, Ms. Kitchen? There was issue number 2 and number 3.
I think we can still address issue number 3 because it was several questions about whether other issues in the plot comply with code, but issue 2 would go away.
Okay. Everybody in agreement with that, Mr. Rowland?
I'm sorry, we might have to identify what we might issue 2, issue 3, just so I'm tracking.
Okay. Issue 3, does the Mills subdivision plat comply with code? And by just having voted the way we voted, we are really not sure whether it does or doesn't. Isn't that true?
I agree with that.
And if that's true, why do we even bother with discussing item number 3? Whether it complies or not. It seems to me that if the planning board finds that the easement exists, then it complies with code. Or are you referring to the additional 4 issues that the appellant presented?
Yeah, there are 4 issues that the appellant presents, whether it complies with code, and I think that we have to address that or consider it, send direction to the planning board to consider it on remand.
So, really, and those are the 4 issues, remember, that the appellants raised. But really, we are talking about finding number 7, that the plat complies with code. Paragraph number 7 of the planning board's decision. Does it comply with code or not? In other respects, not the easement. We're done with the easement issue. But does it comply with code in the other respects that have been raised, yes, by the appellants, yes or no? That's really what we're talking about, isn't it?
I would agree.
So, Mr. Chair, we're talking about the water course mapping, we're talking about the drainage issue, we're talking about the Adronomus and fish stream.
Exactly.
That string of issues that were in
Yes.
the briefs.
Yes, that's what we're talking about. So, really what we then have is the planning board's finding number 7, that the proposed subdivision complies with code, is supported by substantial evidence, except with regard to the easement issue. And I'm looking at you, Ms. Kitchen. Isn't that
Yes.
true?
Yes, I would
So-
agree, that's true. Do you want me to go through the issues that were presented?
Well, go ahead.
First, the appellants challenge whether the planning board's factual finding, code compliance, whether the planning board addressed code compliance in both its factual findings and plat approved conditions first, whether the planning board's factual findings and conditions specifically address water course mapping. Second, whether the planning board conditions its approval on compliance with well and septic code requirements. Third, whether the planning board addressed code compliant public trails in its factual findings and conditions. And fourth, whether the board's decision addressed applicable setbacks and open space requirements.
Okay. So we could do a motion that says, in essence, that the planning board correctly found that water course mapping issues, well and septic requirements, trails and setbacks have been addressed in a manner required by the code. Isn't that right?
Yes.
Mr. Chair, I would make that motion.
Thank you. And I will second that. Mr. Rose.
Thank you. So I think that if we look at finding of fact number 7, finds the petitioner is exercising their legal right to subdivide property in a manner compliant with Anchorage Municipal Code. All of these complaints and concerns, if we just group them together, these were discussed pretty thoroughly, I think, through the record, there was quite a bit of public testimony, I think, on these issues. I don't know that the planning board is required to make a finding of fact as to each of these individual things in their findings of facts. I don't know that they're required to. I think that this paragraph 7 does that by saying everything is compliant. So the fact that these are factual issues that were brought before the planning board, is there the appropriate setback, the water course issue, etc. Those were factual issues where the planning board was tasked with considering that issue and comparing it with the code and making the factual determination of whether or not that the plat complied with that. they made that factual finding. This is a factual finding that I think is within the boundaries of what they have the authority to do, and they didn't act outside of it. So, that being a factual finding, I think that we can only reverse if we unanimously agree to substitute our own judgment. I'll say, on my view of the record, I don't see error here. I think that the planning board did an okay job on this part of it. So, my take on it is that we at least affirm the planning board on these kind of miscellaneous issues that are brought up at the back end of the appellant's brief.
Being the second of this motion, I agree with your comments. I would like to add to that specifically there are conditions that the planning board order adds. For example, condition number 2, resolve with on-site water and wastewater necessary approvals for on-site water and wastewater systems to service the existing cabins on tracks A and B. Or number 3, resolve on-site water and wastewater, the need to submit plans, et cetera, that require approval. So they have addressed it not necessarily by finding that it complies, but making it conditions of approval of the final plat. So I think, and I would agree that the objections raised by the appellants are not well-founded under the circumstances, because the board has made the right decision here to require compliance with those items, and they do not have to be contained in the preliminary plat as long as they are addressed before the recording of the final plat. Mr. Probst.
That was my take, that the issues were adequately addressed in the preliminary plat, and they will be, finally addressed in the final plat, and there's nothing more for us to do.
Ms. Kitchen, do you have anything further that we need to address here regarding this issue?
No, I would just say that the legal standard is that you defer to the planning board's judgment on these factual findings unless by unanimous vote you substitute your independent judgment. It sounds like here you would like to defer to the planning board's judgment on these factual findings.
Okay, does that need to be contained in the motion? It doesn't, does it?
I don't think so. We can flesh that out in the findings and conclusions.
Okay, all right. Anything further regarding the pending motion? Mr. Rose?
Call the
The
question.
maker of the motion, okay, Mr. Probst, anything further?
No?
Madam Clerk, would you call the vote, please?
Chair Gujarat,
Yes?
Member Crooks,
Yes.
Member Rose.
Yes.
All right, the motion passes 3-0. All right, I think we have adequately addressed all existing issues. Normally, I can tell you that when this board rules on an appeal, it is desirable to put the matter to bed. And the way that that is done is there is a directive in the code that says, when you're ready to do this, you render a final decision, and you list and you add at the bottom that each party involved in the case has 30 days to appeal to the Superior Court. That's a final decision by this board. Unfortunately, we're not able to do that in this particular case for the reasons that we have now argued over for almost 2 hours. So it seems to me that we have done the best we could under the circumstances, and I think in retrospect, the planning board will want to think about this, and I think our resolution of the case gives them adequate opportunity to do just that. And so with that, I think we will simply say we have addressed the appeal in all material respects, and we will simply get together to put it in writing for transmittal to the parties and to the planning board and to the planning board and to the planning department. And whoever else needs to get a copy of the decision. So, having said that, then we need to simply agree on when we get together to discuss the final decision that we have come to conclude here today. And we had initially said that we schedule this for February 14, I believe.
13.
13, okay. I would like to change that date to the 9th. At the same time, that is 1 p.m. So that we get together again, hopefully. Maybe we have to have Mr. Rose join us by video conference or in some other fashion, I'm not sure. We'll discuss the details. But as long as we can agree that we will get together on February the 9th at 1 o'clock to finalize the decision, the decisions that we've reached today. Is that agreeable, Mr. Rose?
Right, I'll just note, while we're on record, I'm in trial that week. That's the last day of the week of the trial, so I might be done by then, I might not. I might take a recess then, I might not. So I will do everything I can to carve out the time. And I will, of course, let everyone know ahead of time if it's looking like that's not gonna happen, so that we can reschedule it back to 13th.
Well, either reschedule it or you join us by way of Zoom.
Through the chair of Teams.
Yes?
Yes.
Thank you. Okay, so anything else that we need to bring up?
Question,
Yes,
just procedurally, so the meeting's on the 9th, and sometime prior to the 9th, we'll receive
Yes.
Ms. Kitchen's.
definitely.
Okay, good,
You will receive a draft,
yes.
and then we can argue over this. Does that answer your question?
Yes, it does.
Okay. Mr. Rose, anything further that we need to bring up?
No.
Ms. Kitchen, anything?
Nothing for me.
Well, thank you. And I have nothing further. And with that, this meeting is adjourned. Oh, I forgot something. I apologize. Thank you.
We do have other.
I'm so sorry. I apologize to the members of the audience. It's no old business. Member comments, I doubt very much that there are.
I've spoken my piece.
Yes, Mr. Frank.
I'm just thinking, you made some mention, I don't know if this is your last meeting, the next meeting is your sunsetting. So what are we going to do? I mean, what are your thoughts on this?
Well, you know, I'm definitely off the board, there's no question about it.
Okay,
You know, I have been the chair of this board for over 10 years, that's enough.
it's enough.
And, you know, we are all getting a little older and we have other obligations, and that applies in my case. So my term officially ended in October. There is a provision in code that allows for 4 months subsequent to the expiration of a term to sit on matters, and that's how I'm here today. Now, the 4 months are up on the 11th of February. That's why I'm anxious to get this concluded before the 11th.
Sure.
Okay? So that's what leads to this. I have been concerned about finding additional members for this board. And that I've been singularly unsuccessful in that regard, unfortunately. Mr. Probst, you were my suggestion. I do know that. That's how you got on this board. Mr. Royce, you did this somehow independently. I didn't know you beforehand. I really appreciate your comments. I want you to know you have been very instrumental in helping out here. So, good luck.
Likewise, Mr. I think it was a very vigorous debate. I enjoyed it.
Oh, that's why I enjoyed this board always. So, having said that, this is the last substantial hearing that I'm participating in. You know, the final decision is kind of a mop-up operation. So that's why it is scheduled for 1 hour instead of 3 hours. But you need to find other board members. There should be 5 members on the board. And we don't know whether Nancy Pease has reapplied or not.
Through the chair, she has, it's just been pushed by the assembly members, so I think it's being seen in,
I think the public hearing is the next meeting.
yeah, I think the public hearing is February 13th for her.
Oh, so she has been
She has,
reappointed by the mayor.
yes, but she hasn't been approved by the
Yeah, I
assembly
understand,
yet.
yeah.
Yes.
Oh, I'm so pleased to hear that. You will enjoy neither one. Yeah, I think you have.
I know her, yes.
She is very articulate, she is very bright, and she is not afraid to speak her mind. So I've always enjoyed working with her. The one problem is that she is a very active member of the public in the south side of town, and so she is constantly excused from considering cases because she has already participated in a prior phase. So that's why it is important that you find additional candidates to serve on this board. It's really important. And remember, we are doing a service to the public. And it's totally non-political,
I agree.
you know, so it shouldn't be very difficult, but it has been. Okay, so,
I'm just gonna
Yes.
chime in on that, and I think that if you have any recommendations, sending them to Dean Gates is a great way to move forward, isn't that correct?
absolutely. Dean is the right person to know about this and to help you out. But it's also, now previously I've worked with the clerk's office. Barbara Jones has been very helpful, and I would suspect her successor is going to be equally helpful. So it is either Dean Gates or the clerk's office, the clerk.
Through
I
the
should
chair,
say.
we do have Sam Laffey too, so we just have one seat that's open,
One seat that is open,
Yes.
okay.
and that's yours.
He will be, in terms of planning board decisions, he will be precluded for a while longer because he basically just resigned from the planning board. Yeah, very true. Okay, I have nothing further to say. Audience participation. Audience participation? There's no audience left, and there isn't anybody on the telephone, is there? Mr. Meacham long left?
Through the chair, yes, he left. There's no one on the
Okay.
phone.
All right. So there is no audience participation, and now we can adjourn. And having said that, I'll try it for a second time. Adjourned.
Good.